Professor Bob Moles, who was on his way here before I got in his way. Bob, come over here. I know him to be a good man in the right sense of the word, not like the captain. He's dedicated his life to fighting for the wrongs of the unjustly convicted, and I don't know if he'll tell you what cold and lonely work this can be and how it has little personal or professional benefit, especially if you operate in a small town like Adelaide or perhaps even like Hobart. I know Bob well enough to know the personal bravery that he's shown, and that because neither the establishment nor, curiously, the public actually want to appreciate this kind of rocking of the boat. The public actually want to believe that up there they know what's good for us and the court always gets it right. Now, I can understand why they feel like this, because if that isn't true, then none of us are safe.
That's right.
I introduce Bob, as I always do on Australian television, Australia's foremost expert on the miscarriage of justice, but also, as I just said, as a good man.
Thank you, Charles. That's very much appreciated. I would just like to mention that the papers that BB and I are giving this evening have already been published this afternoon, about 2 minutes before we got here, on the Networked Knowledge website. Not because I think that they're so fascinating that you'll want to hear them all over again, but because they contain the references to the various cases and issues that we've referred to, and you can, by clicking on those electronic versions of the presentations we're giving this evening, follow up on them and check them for yourself. In a recent article, the president of the Law Society in Tasmania referred to the various proceedings which had taken place in the Neill-Fraser case, and he stated that continuing criticisms of the prosecution and police might undermine confidence in our criminal justice system. The Director of Public Prosecutions, in his recent annual report, states that all cases have been dealt with in accordance with the relevant legal principles and codes of conduct. I respectfully disagree with that and ask them to consider and respond to the issues I'm about to raise. It is clear that the number of proceedings which have been undertaken can provide no guarantee that the outcome is correct. In the cases of Graham Stafford in Queensland, Andrew Mallard in Western Australia, and David Eastman in the ACT, each had many unsuccessful appeals before the convictions were overturned. David Eastman had 11 of them. The president of the Law Society suggested that those calling for an inquiry should consider all of the evidence at the trial. He thinks it shows the verdict to be correct and that an inquiry is unnecessary. I say a review of that evidence shows that the trial was fundamentally flawed. The purpose of an appeal is to determine if the person convicted received a fair trial. If evidence had been wrongly admitted or found to be unsound, it has to be established if there is a reasonable likelihood that it might have influenced the jury in arriving at their verdict. If that is so, then the verdict must be set aside. It creates reasonable doubt. There are compelling strategic reasons, I would say, for focusing primarily on the evidence given at trial for the purposes of an appeal. At the Neill-Fraser trial, the forensic scientist said she decided to use a preliminary screening test called luminol to identify the possible presence of blood. When sprayed in a darkened room and subjected to a special light, it might give a bluish glow for about 30 seconds in the presence of blood. However, she acknowledged, it will also respond to many other substances, including metals, cleaning agents, fruits, vegetables, soils. With regard to the significance of the test results, she said, I certainly can't say that there was any blood present or not, because I haven't made any attempt to confirm it, but I do have a positive screening test. She also agreed, I've no way of knowing if luminol is responding to blood or any other substance. In other words, without doing a follow-up confirmatory test, the luminol test result on its own is inconclusive and inadmissible. This was confirmed in the 2008 case of Keith Smart in Victoria, where the judge ruled, "I would not admit the evidence in relation to the luminol positive areas where there is no confirmatory testing." I say that is what should have been done in the Neill-Fraser case. In the cases of Lindy Chamberlain and Edward Splatt, it was found that preliminary test results were misleading and had led to wrongful convictions. In the UK cases clearly support the inadmissibility of screening tests. In the IRA bombing cases, the scientists swabbed the hands of the suspects and said the results showed a positive result for nitroglycerin. Nearly 20 years after they were convicted, it was revealed that soaps, boot polish, and the plastic backing on playing cards would also give a positive result. The judges made it clear that the misrepresentation of screening test results, as if they were probative, constituted a serious error. Convictions in the cases of the Maguire 7, the Birmingham 6, and the Judith Ward case were overturned. The appeal court found that the three scientists had given false and misleading evidence. It said the evidence derived from the screening tests cannot be regarded as more than an initial step towards the identification of nitroglycerin. The scientists' conclusions were wrong and demonstrably wrong, even by the standards of 1974. The scientists had placed a false and distorted scientific picture before the jury. And the Canadians agree with us on this issue. Around the time of the Neill-Fraser trial, a judge of the Supreme Court of Canada was giving an important public lecture in Edinburgh in which he stated in relation to the recently published Forensic Investigations book, which can be inspected on the table there if you so wish, he said, in their study of miscarriages of justice in Britain, Canada and Australia, Professors Sanger, Roach and Moles identify recurring problems common to the experience of those jurisdictions. These include the use of preliminary screening tests as conclusive evidence. That's a judge of the Supreme Court of Canada. After the expert witness in the Neill-Fraser case said she had no way of knowing if luminol was responding to blood or any of the many of the other substances that would give a positive response, she went on to say, with experience and judging by the quality of the sparkling, the flash, the colour and the longevity of the response, she could tell whether the test was responding to blood or any of the other 100 or so substances. This is a remarkable and unsubstantiated claim. The law requires that an expert witness must provide the jury with the observations and scientific principles which support the reasoning so that they, the jury, can make their own independent assessment of it to determine if it is reliable. There was no suggestion at the Sue Neill-Fraser trial that the witness had measured or recorded the longevity of any of the responses, or recorded any of the flash, the colour, or the sparkling of the results. The jury was simply told that the witness had made those judgments on the basis of criteria not available to the jury. The cases make it clear that subjective and unsubstantiated impressions of experts are not admissible as expert evidence. In addition, the law requires that the scientific principles used by the witness must not only be explained, but must also be part of a reliable body of scientific knowledge. This requires reference to scientific texts or articles setting out the results of the experiments to validate the criteria being used, and that was not done either. The witness merely continued to express her belief that the responses she observed were to blood, saying, "I found what I believed to be blood samples on the yacht. I don't think I tested any of the samples which came off the Four Winds." She continued to state that when she referred to red or brown stains in her report, she meant them to indicate the presence of blood. Defence counsel assisted the prosecution case by suggesting to the witness that someone might try to clean up a crime scene using domestic household cleaning methodology. He asked whether luminol might still detect minute traces of blood, and the witness said that it might well do. Knowing that luminol would give a positive result to many household cleaning agents, it would appear that cleaning up the boat and cleaning up a crime scene would now be indistinguishable. The witness said that she used a black texter to outline areas which gave a positive result, in order to make sure that she got all the edges. She drew markings to include a wide margin. She then added, "Within this area, I can't tell you exactly how much of it, but within this area is the area that was positive with luminol." We can only infer that the pictures shown to the jury of the so-called blood-responsive areas significantly exaggerated them. The witness was then asked about references in her report to possible drops of blood. She said that in conducting her tests, when she found evidence of some drops, she was unsure whether that indicated drops of blood as part of the crime scene, or perhaps drops which came from her spray bottle. Defence counsel said, "Right, and does that mean possible drops from your spray, or they were possible drops of something on the deck?" And the expert witness said, "That's correct. It's either of those two things." So she reported them as possible drops in order, she said, to prevent any possible confusion at a later date. It's clear that if the crime scene examiner cannot distinguish herself whether evidence was part of the scene or amounted to contamination by her, how could members of the jury be expected to sort it out later? Her detailed references to blood about the boat and the dinghy were intermingled with repeated expressions concerning her beliefs or assumptions about what was blood or not blood. The wheelhouse steps near the wheel, the vent, cushions, seats, walkways, shelves and panels in the saloon. In the dinghy, she referred to an area that was positive with the luminol screening test for blood. She pointed to this run down here, you can see, it's just the chemical itself running down towards the back. She said confusingly that the glow is very pale, even though I'm calling it strong and weak. She then added, even when it's strong, it's not particularly bright. So we spray multiple times to enable it to come out in a photograph. That's why, she said, the overspray of the chemical is then run down towards the back and pooled at the back. Now, it should be explained that luminol has an intrinsic glow. So if it is sprayed on an area several times, it will auto-luminesce and give the appearance of a positive reaction, when in fact it's not reacting to anything at all. At the same time, she has said that it's the quality of the glow response which indicates the presence of blood. It appears, after all, that a repeated application will increase the glow response, which then can be used to falsely indicate the presence of blood. No wonder that luminol is not used as a confirmatory test of anything. It's clear that whilst the explanations by the expert witness were inconsistent and confusing, they indicated to the jury that there were extensive indications of blood about the cockpit, galley, walkway and dinghy. So is there a reasonable likelihood that such evidence might have influenced the jury in arriving at their verdict? If so, and knowing it to be inadmissible, the only conclusion must be that the verdict must be set aside. The forensic scientist was also asked some questions about DNA. She stated at the outset that she was not an expert on DNA. The judge asked if she had overheard experts on DNA in her laboratory discussing these things. She said she had. The judge then said, on the basis that she had overheard the discussions, he was now going to regard her as an expert on that topic for the purpose of these proceedings.
Seriously?
I have to say, in case you doubt it, that that is not consistent with the rules on the admissibility of expert evidence. The prosecutor asked the pathologist whether it was possible for a man of 65, frail and a smoker, to be killed or rendered unconscious by a single blow. He said it was possible. He was then asked if the same results could be achieved by multiple blows, as if that made any sense. He was also asked if it would be relevant if the blows were to his head from behind. He was even asked if a person could be killed by a single blow to several parts of his body, as if that made sense. The pathologist agreed that a man could be killed by a blow or blows with a blunt object, and that a stab wound might send a fine spray of droplets to objects. The prosecutor asked if age and frailty would have anything to do with the susceptibility to dying or being rendered unconscious. And the pathologist complained, at last, that the exchange was getting very speculative. I should add that the law is quite clear on this point. The High Court has ruled that for obvious reasons, speculation in the context of criminal trials is not permitted. People are to be tried on facts, not imagined circumstances. In Straker and the Queen, 1977, the High Court made it clear that speculation adverse to the accused when there is no evidence to support a conclusion that the fact was established is not allowed. Surprisingly, Defence Counsel, instead of vigorously objecting to all of this, commenced the cross-examination with the words, "Now, just continue this speculation." He asked if a person taking aspirin would bleed more profusely if bashed over the head, and how such bleeding might be affected by knife wounds. He got the witness to confirm that anyone could die from a single or multiple blows to the head. And this clearly had the effect of reinforcing the view that all of this is relevant to the issues to be considered by the jury in this case. The law makes it clear that before an expert opinion evidence is admissible in court, it must be established that the facts relevant to the opinion have been or will be proven by admissible evidence in the course of the proceedings. Clearly, that was not the case here. The other objection is the failure to consider if the expert opinion is necessary to assist the jury to interpret the evidence. An expert witness is not allowed to express an opinion if ordinary members of the jury can understand the issue without the assistance of the expert. There's been much public discussion about the need for additional laws to deal with people who hit other people and so cause death by a single punch to the head. It's clearly public knowledge that a person could be killed or rendered unconscious by a single blow, whether to the head or other parts of the body. They do not need an expert to explain that to them. It's also perfectly clear here that there was no factual basis for it in the evidence. The nature of the problem can be summed up by reflecting upon the words of the prosecution in opening questions to the pathologist. We don't have a body in this case. It might also have been said, we don't know if there is a body in this case. All that is known is that Mr. Chappell disappeared from his boat and has not been seen again since. It's clear that the prosecution initiated this line of questioning to support speculative submissions to the jury about how Mr. Chappell might have been killed. The prosecutor will go on to suggest that Mr. Chappell was beaten with a heavy metal object or stabbed, and the judge will go on to accept in sentencing that was probably the case. Yet it could not be clearer that there was no factual basis to support the claim that Mr. Chappell was beaten, bashed or stabbed. The questions and answers should have been held to be inadmissible. And although Defence Counsel was willing to continue this speculation, it would have been better if he had put a stop to it. It is not the business of counsel to encourage the jury to engage in inadmissible speculation, which is seriously adverse to the interests of his client. The question to be asked upon any appeal is whether this inadmissible evidence might reasonably have influenced the jury in arriving at their decision. If it might have done, then the verdict of the jury must be set aside. But there are also prejudicial and inadmissible submissions by the prosecutor and the judge. We can now see how the prosecutor, supported by the judge and the inadmissible evidence, referred to build a scenario about a murder, which is also inadmissible. The prosecutor informed the jury that wrenches had been found to be missing, adding, "A great big 53-foot boat, they'd need a bit more than a tiny little wrench." The evidence indicated that a big wrench had not been found on the boat. That is not quite the same as one being missing. The suggestion that the size of a wrench could be inferred from the size of the boat is clearly an invalid inference. The size of a wrench must relate to the nature of the equipment or machinery to be worked on. And the prosecutor told the jury, "She's walking backwards and forwards. He's getting increasingly angry." There was no evidence whatever to support those assertions. And in the development of the scenario put to the jury by the prosecutor was anger. Bang! Maybe once, maybe twice. He then adds, "She's walking backwards and forwards," and delivers a blow, or blows, or maybe stabs him with a screwdriver. I don't know. He doesn't look round, and so the body doesn't have any marks of what you'd expect if someone had come down there, a stranger intent on doing harm. The body, I suggest, would have marks consistent only with being delivered by someone who he knew to be there and who he knew and expected to be behind him. There is no evidence that anyone had been struck by a blow. No evidence of anyone being stabbed with a screwdriver. There's no evidence of any body having any marks. There's been no expert evidence to justify the claim that one can distinguish from the marks whether they were delivered by a person known to be there or by a stranger. And the prosecutor then adds another astonishing suggestion to the jury. Here is perhaps the significance of there being no body found. Why, if this is a complete stranger to Mr. Chappell and a complete stranger to the boat, would there be no body left on board? So the prosecutor is inviting the jury to infer that no body being found must implicate a person known to the person, because a complete stranger would not attempt to dispose of a body. That is clearly untrue. If any person, friend or foe, had killed Mr. Chappell, they would have the same interest in disposing of the body because of the potential for there to be some evidence to connect them to it. There is no criminological hypothesis to suggest that only family members or friends dispose of bodies, or that strangers will leave bodies of victims to be found by the police. Given that the prosecution has already accepted we don't have a body in this case, then there can be no possible basis for making assertions about the type of injury the body does or does not have. The trial judge acknowledged that there was no direct evidence that the accused killed the deceased. He also observed there was no direct evidence of the circumstances of the homicide. In a circumstantial case, one might have thought the lack of evidence, direct or otherwise, on these two crucial issues might have been sufficient to dismiss the case. Despite this, the judge thought it quite likely that the appellant hit the deceased on the head with a heavy wrench from behind, but concluded that the evidence did not enable the making of a detailed finding as to the manner of the attack. However, as we all know in criminal cases, quite likely is not the standard to be applied in a criminal trial. A conviction for murder requires proof beyond a reasonable doubt. The judge could not make a detailed finding about the manner of the attack because there was no evidence that any attack had occurred. As he told the jury, you might think there's no evidence as to what went on because there's no evidence as to what happened to Mr. Chappell. Yet, despite there being no evidence, the judge in his sentencing remarks was content to accept that it was quite likely Mr. Chappell had been struck by a wrench. In the Gordon Wood case, it was alleged that Mr. Wood had thrown his girlfriend from the cliff in Sydney by using a javelin throw. In his address to the jury, the prosecutor had mentioned a javelin or a shot put throw. The appeal court judge was severely critical of the prosecutor for putting a proposition to the jury about a shot put throw, for which there was no evidence. He said the submission was extraordinary and should never have been made. It was entirely unsupported by any evidence. The experts had really just referred to javelin throws. None of them had mentioned a shot-put throw. Just a little point, you might think. The suggestion of a shot-put action, he said, was an invention of the prosecutor during the course of submissions, which was absolutely no support in the evidence. In making assertions about what marks the body does or does not have, the prosecutor here is assuming the role of a witness. In suggesting a possible correlation between the existence of such marks and the potential identity of a perpetrator, he's acting as an expert witness and providing opinion evidence to the jury about the interpretation of patterns of injury. All this is being done in front of the jury in circumstances where all agreed there is absolutely no evidence to support it. There's no body, there are no injuries to be explained, there's no possible basis on which to exclude strangers or include family members or friends. The whole scenario should have earned the same rebuke as did the shot-put submission to the jury in the Wood case. It was an invention of the prosecution and should never have been made. It is clear from recent decisions of the High Court that once the prosecutor invites the jury to engage in impermissible reasoning, the conviction cannot be maintained. That being so, the only question to be answered is whether it is reasonably arguable that these inadmissible remarks by the prosecutor could have influenced the jury in arriving at their verdict. If they might have done, the verdict of the jury must be set aside. And as regard the drug smuggling issues, Miss Neill-Fraser had expressed concerns that others might have used the yacht for drug smuggling purposes. She said if Mr. Chappell had been on the boat at night without the tender alongside with no lights, it might appear that there was nobody on board. If drug smugglers had been involved, they might have taken the opportunity to recover the drugs and then unexpectedly confronted Mr. Chappell. The prosecutor told the jury Miss Neill-Fraser had wanted the police to search the boat with dogs and urged the police to follow that line of investigation. However, in his closing address to the jury, the prosecutor stated that the whole story of smuggling, a constant theme of her talks to the police, was, he said, when you think of it, it's nonsense. It was a ridiculous thing when you look at it logically. And why was that? The prosecutor asked the jury why the body would be taken away from the scene of where he was killed somewhere secret. Why would these smugglers bother? It doesn't make sense. He added the whole thing was a fabrication on her part. In asking such a question of the jury, the prosecutor is effectively reversing the onus of proof. Knowledge about empirical correlations between smugglers, killers and body disposals is not a question of logic at all. It's a sociological question about patterns of behaviour. To tell the jury that smugglers would not dispose of a body after they had killed someone was not supported by any evidence to that effect. It's to invite the jury to engage in impermissible reasoning, which of itself would warrant the conviction being set aside. To suggest to the jury that such concerns are ridiculous and nonsense is also inconsistent with the facts which the prosecution ought to have known about and failed to disclose. Shortly after the trial in November 2011, the Australian Federal Police reported that drugs were found in a yacht which had arrived in Bundaberg, Queensland, after travelling from Vanuatu in the Pacific. The drugs had an estimated value of 78 million, and 3 million in cash was also found. On the 3rd of April 2014, it was reported that a lucrative and high-volume drug smuggling operation had been utilising small yachts to access ports along the eastern seaboard of Australia for many years. The Channel 9 60 Minutes programme reported on the multi-billion-dollar cocaine war that stretches all the way from South America to Australia. It said that small yachts are loaded up with hundreds of millions of dollars worth of the illegal drugs on the coast of Ecuador before making the long journey here. It reported on a case involving smugglers from South America to Vanuatu and Tonga, where a boat holding 200 kilos of cocaine and a rapidly decomposing corpse was discovered shipwrecked on a remote island reef. The Australian Federal Police had issued a statement to say that they have had a presence in South America since 1989. It added that since September 2010, the Neill-Fraser trial commenced 21st of September 2010, the AFP had seized some 1.9 tonnes of cocaine that had transited through the Pacific en route to Australia with a potential Australian street value of approximately 570 million. It stated that in 2002, 8 years before the Neill-Fraser trial, the AFP had established the Pacific Transnational Crime Network, which had grown to 18 transnational crime units in 13 Pacific Island countries. The information about the history of these activities was not disclosed to the jury at the Neill-Fraser trial and represented a serious non-disclosure by the Crown. It clearly contradicted the submissions being put to the jury. The prosecution should have known that there was a very genuine concern by the police involving the smuggling of large quantities of high-value drugs in small yachts loaded up with hundreds of millions of dollars of illegal drugs. The Australian Federal Police had been active in this area since 1989 and had a crime network since 2002. Indeed, on the very day the jury retired to consider their verdict in this case, the ABC reported a major drug find on a yacht on a marina in Brisbane, Queensland. The evidence in this trial was completed on the 13th of October 2010, and the following day Justice Blow summed up to the jury at this trial. On that day, this major drug find was announced, which involved the precise locations where the Four Winds had been just before Mr. Chappell's disappearance. Scarborough Marina, Brisbane, the same marina from which Mr. Chappell and Miss Neill-Fraser had brought the Four Winds a few months earlier, and Eden in New South Wales, where the yacht had overnighted on the voyage down from Brisbane to Hobart under the direction of the paid crew. It clearly contradicted the suggestions by the prosecutor that Miss Neill-Fraser's concerns in this regard were unfounded or designed to mislead. The Home Affairs Minister is reported to have said, "This is a fantastic effort by the Australian Federal Police, Customs and Border Protection and Queensland and New South Wales Police working together." It would be surprising and disappointing if the prosecutor at the Neill-Fraser trial was unaware of all these revelations. But even if that were so, it would not be of any assistance in defending the prosecution's position. It's well accepted that there is no distinction to be drawn for disclosure purposes between the prosecution and the police. If material is known to the police, the accused is entitled to it, whether or not the individual prosecutor knows of it. From a legal point of view, concerning the adequacy of the Crown's disclosure at a trial, it's unnecessary for these purposes to investigate whether the prosecutor had actual knowledge of the information. If the jury had known about this information before delivering the verdict, as clearly ought to have done, it might well have affected their assessment of whether Miss Neill-Fraser had reasonable grounds for her belief, or whether she was engaged in fabrications, as the prosecutor had suggested. The prosecutor emphasised in his closing address to the jury that raising red herrings and laying false trails and so on might all give the impression that there must be a reasonable doubt. He said her reference to a break-in or drug smugglers is all a red herring, deliberately vague to put police off her track. And they're all another break-in. It's clear that under Australian law, the prosecutor must act as a minister for justice. The prosecutor's code of conduct says the prosecutor must not express by inflammatory or invective language the prosecutor's personal opinion that the accused is guilty, or press the prosecution's case for a conviction beyond a full and firm presentation of that case, or by language or other conduct seek to inflame or bias the court against the accused. The question on this issue, as with all the others we've looked at, is the same. If the jury had known the extent of the drug smuggling operations, is it reasonably arguable that it might have influenced them in arriving at their verdict? If so, the verdict must be set aside.
Hear, hear.
A circumstantial case is one where there are no direct or eyewitnesses to the events in question. The surrounding circumstances then provide the only basis for drawing of appropriate inferences. In such cases, there are special rules which apply. In this case, the judge correctly observed that in a circumstantial case, the conclusion of guilt has to be the only rational conclusion open on the evidence that the jury accepts. If there is any rational hypothesis or any sensible theory consistent with innocence, then Miss Neill-Fraser had to be acquitted. The judge explained how obvious alternative explanations relating to disappearance, accident and suicide could be excluded. If he was mistaken in respect of any one of those, then it would mean that a rational explanation, consistent with the innocence of Miss Neill-Fraser, was still open on the facts, and the conviction should therefore be overturned. With regard to disappearance, the judge dealt with the possibility of disappearance by saying, there is evidence that tends to establish that Mr. Chappell is dead and gone. However, the matters which the judge referred to do not provide evidence for it. He said, there is the evidence from the family of not having heard from him. That is, of course, of what they would say if Mr. Chappell had just disappeared. The judge then observed that police inquiries of Medibank and Medicare have revealed no sign of him still being alive. In fact, the underlying observations are that there are no confirmed sightings of him and no activity by him or attributed to him. That is what one finds in all cases where people have disappeared. In effect, the judge is citing evidence of disappearance as if it were proof of death. This is clearly an invalid and inappropriate inference and would collapse the distinction between a person who has disappeared and one who has died. The National Missing Persons Coordination Centre states that each year 38,000 people are reported missing in Australia. While 95.5% of people are found within a short period of time, there remains approximately 2,000 long-term missing persons, those who have been missing for more than 3 months. It would be irrational to infer that they were all dead because they'd not made bank or Medicare transactions. There is no principle by which one can discriminate between the missing and the dead apart from the discovery of the body or evidence of it. None of this was mentioned in the course of the Neill-Fraser trial to assist the jurors to obtain a sense of perspective in relation to these issues. In relation to accident, the judge stated in his summing up to the jury, so there's also evidence that tends to suggest that what happened was not an accident. However, the factors which he cited failed to support that conclusion. The judge stated, the evidence that the Four Winds was sabotaged tends to suggest there was no accident. Clearly, proof of damage to the boat is not proof of damage to the person of Mr. Chappell. Indeed, the two events could be entirely unconnected. There's nothing to exclude the possibility that Mr. Chappell could have gone off somewhere, had an accident, and later on some people came across the yacht and, being unattended, caused damage to it. The judge also referred to the fact that the blood in the yacht tends to suggest there was no accident. The reference by the judge to the blood emphasises to the jury the significance of the various and inconclusive test results which were inadmissible. The judge also stated there's evidence that tends to suggest that Mr. Chappell didn't commit suicide. He referred to Mr. Chappell's son, who said that Bob wasn't depressed or suicidal. However, such views, even if correct, cannot be said to be contraindicative of suicide. There are countless examples of people who commit suicide in circumstances which come as a great surprise to their families or friends. It was said that Bob was interested in his work, regarded it as important. Again, sadly, many people in similar situations do commit suicide. As the authors of a recent study on suicide stated, the reasons for a suicide are never really knowable. They point out that there have been some 30,000 academic papers on suicide published between 1980 and 2011. They cover complex issues in fields such as psychiatry, psychology, genetics, neuroscience, and sociology. None of this was referred to in the evidence at this trial. If one is to conclude from observations about suicidal ideation and interest in work to a conclusion about the probable occurrence of a suicide in a specific case beyond reasonable doubt, then one would have to demonstrate that the conclusion is not only compelling but also consistent with medical, psychological and sociological studies in this area. Regrettably, the judge had no expert advice on this topic to assist him, and best that one could say is that his own intuitive assumptions in this area are not a satisfactory legal basis on which to encourage a jury to convict someone of murder. And the judge added, and if he did commit suicide, it's hardly likely that he would have scuttled the yacht. The basis for this probability assessment by the judge is unarticulated, but clearly presupposes principles concerning suicidal behaviours. It represents another issue where the judge is not simply commenting upon the evidence for the assistance of the jury, but is introducing a form of junk expert evidence in the guise of comment, which is clearly unacceptable. If a person was in a frame of mind to inflict life-threatening damage to oneself, then why would they not be likely to inflict damage upon their immediate physical environment? A suicidal person might well burn their house down or drive the car off the cliff. However, to suggest, as the judge does, that a person who's willing to kill oneself would not be willing to cause physical damage to some inanimate object, such as a boat, appears to be a non sequitur. The judge added that suicide would be unlikely because he wouldn't have tied the extinguisher to himself and disappeared without a trace, and that is clearly unacceptable. The judge is not entitled, in summing up to the jury, to make assertions of fact which are unsupported by any evidence. It's the role of the jury to determine what the facts are. There is no evidence to suggest that Mr. Chappell and the fire extinguisher were united in some final and fatal embrace. Neither Mr. Chappell nor the fire extinguisher have been located. For the judge to put this proposition to the jury as if it were an established fact is not only prejudicial, but invites them to engage again in impermissible reasoning and to wrongly exclude the possibility of suicide. As the judge explained in his earlier remarks to the jury, basing your verdict on the evidence means that you mustn't use guesswork or speculation in arriving at your verdict. And this is precisely what the judge himself has done. If it could be said that these inappropriate statements by the judge might have influenced the jury in arriving at their verdict, then as with earlier issues, the verdict must be set aside. In summing up, I only have to be correct on any one of the propositions I put forward in this paper to warrant the conviction being set aside. On the other hand, the prosecution would have to be able to dismiss each and every one of them beyond reasonable doubt for the conviction to stand. My view is that there should be a further appeal raising these issues. They are focused entirely on the transcript of the trial and the very strong strategic reasons for using that as a basis for any appeal, and call for their assessment in the light of well-established legal principles. Fresh evidence is required for any further appeal under the new right of appeal, and that requires evidence which could not, with reasonable diligence, have been identified at the time of the trial. And so, of course, you might say, how can we surmount that obstacle if you are using the evidence at the trial for a further appeal? It's quite simple. In the case of the Crown against Drummond, a South Australian case, the appeal judge has affirmed that at trial, the accused must be entitled to rely upon the fact that the prosecutor and expert witnesses will comply with their legal duties and the requirements of their codes of conduct. The defence are not required to verify that they have done so. If subsequent to the trial, it is found that there has been a derogation from those principles by a prosecutor or expert witness, then that discovery will count as fresh evidence, and according to the appeal judges, it will most likely also be compelling. Drummond makes it clear that the issues raised in this paper provide, in my view, a proper basis for a further appeal, and I have no doubt that an appeal based upon those issues would be successful if the law were to be correctly applied. Thank you very much.